Unit 3. Types of employment. This unit is designed to introduce types and procedures of employment and additional useful information in employer-employee relations that as a FDI advisor you should know about. After acquiring the relevant knowledge from this field, you will be qualified to understand and implement different types of employment procedure. Understand implementation of national legal provision from work and work relation fields. Introduction. There are several types of employment based on legal regulations on which employment contract between employer and employee can be concluded. Permanent employment. Employment without determination date. Fixed-term employment. Employment with specified reason for employment and set termination date. Seasonal employment. Fixed-term employment with specified termination date. Permanent seasonal employment. The occupational record is active even though an employee does not work. During standby, employer pays monthly retirement contribution while health insurance is paid by the state, as one of the employment boost measures. Employers and employees' obligations. An employer must first arrange for the appropriate publication of a vacancy that can be posted through various media, on its website, on the website of employment agencies, via social networks, radio, newspapers, etc. The advertisement of a vacancy usually includes the essential work tasks that the selected candidate will perform at the workplace, as well as the employer's requirements, level of education, work experience, foreign language skills, other skills and qualities. The advertisement for the vacancy also includes the deadline for registration and the contact person who takes care of the selection of new staff. Once the advertisement for a vacancy has been published and applied for by the candidates, the employer or the person in charge of the selection of the new staff must ensure that the selection procedure is followed, taking into account the constitutional principle of non-discrimination. If the unselected candidate believes that in the selection the legal prohibition of discrimination has been violated, he may request judicial protection before the competent labor court within 30 days after receiving the notification from the employer, to inform potential candidates about the working conditions and inform the unselected candidates on the non-selection. Before starting work, an employer must send a worker to a medical examination and training in occupational safety. Training of employees, which is an employer's legal obligation for all workers, including students, as well as workers who occasionally perform work with him on the basis of a contractual agreement or other legally formal form of employment relationship. An employer must give a worker an annual leave in accordance with the Employment Relationships Act, ZER1, which stipulates that the annual leave in particular calendar year must not be shorter than 4 weeks, regardless of whether the worker is hired full-time or for shorter working time, which is potentially regulated by a collective agreement binding on the employer and internal acts of the employer. When employer has chosen a candidate, the following steps are required. If this is the candidate's first employment or more than 12 months have passed since the cessation of a particular job at a particular workplace, he must first mandatorily pass a preventive medical examination. This is stated in the Occupational Safety and Health Act, ZVZD1. It is advisable to refer every new worker to a medical examination in the occupational health clinic before the conclusion of the employment contract. Prior to the conclusion of the employment contract, the selected candidate must be acquainted with the work or the type of work as well as with other rights, obligations and working conditions. Personal data protection and presentation and acceptance of labor regulations. The EU General Data Protection Regulation, GDPR, is the most important change in data privacy regulation in 20 years. The regulation will fundamentally reshape the way in which data is handled across every sector, from healthcare to banking and beyond. GDPR replaces the Data Protection Directive 95/46/CC and is designed to harmonize data privacy laws across Europe, protect and empower all EU citizens' data privacy, reshape the way organizations across the region approach data privacy. In work relationships, the protection of personal data is particularly sensitive. The assumption here is that the fundamental condition of the contractual relationship between an employer and an employee is trust, which must be reciprocal and is demonstrated by the conclusion of the employment contract or other act with similar consequences. Despite the trust which must exist between the worker and the employer, on the one hand there is a legitimate interest of the employer who has the right to control the use of his assets, for example telephones, computer networks, machines, premises, and the work process, while on the other hand there is a legitimate interest of the employee, who justifiably expects a certain degree of privacy and trust and partial autonomy also at the workplace. It also should not be ignored that the case law of the European Court of Human Rights grants workers the right to a fairly wide range of privacy at the workplace. An employer is obligated to present an employee with labor regulations, if there are any, in order for the employee to read and sign as acceptance. On the other hand, employee has to read it and sign decision of its acceptance. Work safety and fire protection. The Health and Safety at Work Act, ZVZD1, lays down the rights and obligations of employers and workers with respect to healthy and safe work, as well as measures to ensure health and safety at work. This act also defines the competent authorities in the field of health and safety at work. Each company needs to have rules on the requirements for ensuring the safety and health of workers at workplaces. Work safety is a legal obligation for every employer. If he is not qualified himself or does not have a qualified employee, he must use the services of an external associate. A worker has to pass the work safety exam for each new employment. Employment contract. The employment contract is the contract with which the employment relationship is concluded. The employment contract is generally concluded for an indefinite period, full-time, 40 hours a week. Due to the increasing need for work flexibility, contracts are increasingly used that deviate from the standard form, such as a fixed-term employment contract. If a contract does not specify the duration of the contract shall be deemed to be concluded for an indefinite period of time. A contract of employment may be concluded by a person who has reached the age of 15 years. Concluding a contract with a person under the age of 15 is invalid. By law, an employment contract must be concluded in writing. An employer who fails to hand over a work contract in written form to an employee shall commit an offense. Procedure for the conclusion of a contract of employment. Registration of a vacancy. An employer who employs new workers must publish the vacancy or type of work, hereinafter, work, publicly, in the media, on websites or in publicly available business premises. But there is no longer a mandatory publication with the Employment Service of Slovenia, the latter still offers the possibility of a free publication. The mandatory publication of a vacancy at the Employment Service is still valid for employers in the public sector or for companies that are state-owned. The publication of free works must include the condition for performing the work and the deadlines for the application. This time limit may not be shorter than 3 days. You can apply for free work using the application requirement form for workers or trainees which can be completed and submitted through the Employment Service website. A worker must not start work before concluding an employment contract. If the date of the entry into the contract is not specified, it shall be deemed to be the date of conclusion of the employment contract. An employer must provide the worker with a written proposal of the employment contract at least 3 days before the intended conclusion. The employment contract must include information on contracting parties, date of commencement of work, the name of the job or type of work, with a brief description of the work, place of work, the time for which the contract of employment is concluded. Determine whether a full-time or part-time employment contract exists. The provision of daily or weekly working time and the allocation of working time. A provision on the amount of the basic salary of a worker in euros to which he is entitled to perform work under a contract of employment and of any other payments. A provision on the other components of the salary of a worker, the payment period, the payment date and the method of payment of wages. The provision on annual leave or the method of determining annual leave. The length of the notice periods. The indication of collective agreements binding on the employer, or the general acts of the employer, which determine the conditions of work of the worker. Other rights and obligations in cases specified by law. An employer is obliged to register an employee with a compulsory pension, disability, health insurance and unemployment insurance agency at the latest before the commencement of work or, at the latest on the day of commencement of work. The employee must submit a photocopy of this application. See Chapter Registration in Retirement and Health Insurance System. Fixed-term employment contract specifics. The fixed-term employment contract can therefore be concluded in exceptional cases referred to in the Employment Relationships Act. The execution of a work which, by its nature, takes a certain time. Replacing a temporarily absent worker. Temporarily increased workload. Employment of an alien or a stateless person who has a single permit as stipulated by the law governing the entry and residence of aliens and permission for seasonal work as defined by the Act regulating employment, self-employment and the work of foreigners, except where a single permit is issued to on the basis of an agreement for employment, self-employment or work. A manager or procurator. A leading worker, under certain conditions defined in Article 74 of the Employment Relationships Act. Performing seasonal work. A worker who concludes a fixed-term employment contract for the purpose of preparing for work, training or upgrading for work or education. Fixed-term employment due to work during the adaptation period on the basis of a final decision and a certificate from the competent authority issued in the procedure for the recognition of qualifications under a special law. Performing public works or inclusion in active employment policy measures in accordance with the law. Preparation or implementation of a project that is organized in a project. Work needed at the time of the introduction of new programs, new technology and other technical and technological improvements in the work process or for the training of workers. Elected and appointed officials or other employees who are bound to the mandate of an authority or functionary in local communities, political parties, trade unions, chambers, societies and their associations. Other cases provided by law or collective agreement at the level of activity. An employer may conclude several successive employment contracts with the same worker and for the same work, but the continuous duration of such employment may not be longer than 2 years. The law explicitly provides that a 3-month or shorter interruption does not constitute an interruption of the successive conclusion of employment contracts. Exceptions are possible only in statutory cases and in cases where their worker replaces a temporarily absent worker. It is the employment of an alien or a stateless person, under the conditions laid down in the legislation. Their worker is a manager. It is a leading worker, under the terms of Article 74 of the Act. These are workers who are elected and appointed as officials or other workers who are bound to the mandate of an authority or functionary in local communities, political parties, trade unions, chambers, societies and their associations. Teleworking contract specifics. Teleworking contract, work from home, has prescribed content as well as standard employment contract in which additional conditions can be added. Some of the additional elements can be use of equipment, materials, communication costs payment, defining the responsible person, work time, work organization, quality and quantity of products services, business time frame. Teleworking of their employees must be reported to the Inspectorate of Labor before they can begin working from home. They must inform on the name of the worker performing work at home, how much time he will work at home, how much time he will spend on the site, and the content of this work. Workers at home are granted the same rights as workers who work in the workplace of the employer. This applies both to the right to participate in management and to the trade union organization as well as to reimbursing the costs for snacks. Their worker does not receive compensation for transportation to and from work if he does not incur a cost for the time he is working from home. Given that in accordance with the Employment Relationships Act, ZER 1, a worker has the right to compensation for the use of his assets when working at home. In this case, the employer would have to specify in the contract of employment how much of the costs he will reimburse him for. The law does not specify what exactly the compensation for the use of funds would involve, however, in this matter the inspectorate includes the costs of energy, water, maintenance of machines and equipment. Other employer-employee obligations. Certain specific business legislation requires that employees pass additional exams, for example. In some industries connected with user customers' health protection, employee is obligated to pass a sanitary examination. Sanitary certificate has to be renewed within the legal deadline. Employees in catering industry must pass a hygienic minimum exam. Construction workers are obligated to undergo health examination before employment. Additionally, each employer is obliged to choose a specialist of occupational medicine for his employees, usually according to the working place, by filling in the appropriate form verified by a stamp and signature of the responsible person. The employees have to be informed about the responsible chosen specialist of occupational medicine. Registration in the retirement and health insurance system. When hiring an employee, an employer must conduct a registration in Social and Retirement Security Subject Registry. When concluding an employment contract, compulsory health insurance must be arranged by employer, with M1 form. As from the 1st of January 2016, compulsory social insurance must be registered through the EVEM portal. For the purposes of registration, taxpayers are registered as business entities in the Business Register of Slovenia, EGA company, sole proprietor, self-employed person. Registration forms for legal entity and natural person are the same. They can be found on following EVEM portal. Every employer employing at least 20 people has the obligation to meet an invalidity quota, which means that he has to employ between 2 and 6% of disabled people, depending on the registered activity. A taxpayer may fulfill his obligation regarding the quota by employing the prescribed number of disabled people, or paying a contribution to promote the employment of people with disabilities. Detailed information about employment of disabled persons, prescribed formula, professional rehabilitation and employment of disabled persons and regulations can be found on the web pages of the Ministry, responsible for Labour. Management contracts. The Employment Relationships Act, ZER, which regulates labor relations, also specifies the special features of the employment relationship of managers. Managers are the following: Member of the Management Board, Executive Director, Manager, Procurist. By way of exception, also a member of the Management Board. Workers who are regarded managers, or their posts, are defined by a special act of the company, which defines management posts and their powers. For the delimitation between managers and executives, it is essential that in the company that they run, managers hold the status and legal position arising from the ZGD1, while executives do not have such a position. While managers, directors and executive directors hold a legal and contractual working relationship in a company, executives only establish a contractual relationship with the company they work for. The responsibilities of managers are defined in the statutory regulations and in the employment contract. The responsibilities of managers are defined only by the employment contract, the internal acts of the employer or the decisions of managers. Benefits are all benefits, products, services or other benefits in kind, provided by the employer or other person in relation to employment to an employee. Attention also applies if the credit rating is provided to the family member of the employee. The most common credit ratings that employers often offer to employees is the use of a private vehicle for private purposes. A bonus is paid to an employee only if he uses the car for private purposes. In the tax base, in the gross salary of an employee, each month of use is added to 1.5% of the value of the car. This is the case if the employer does not repay the employee for the fuel. If he also pays for fuel costs, this percentage increases to 1,875% of the value of the car. If an employee uses a vehicle for official and private purposes, he must keep a record of the kilometers traveled and consciously separate business routes from private ones. In this context, proper documentation is required, in particular travel orders, in a consistent and detailed manner. Travel orders are, for example, a condition for the compensation of costs. The benefits deriving from an employment relationship are taxed in the same way as earnings from an employment relationship. Thus, they increase the employee's gross income, which means higher income tax.